Good afternoon. May it please the court. Michael Uckman on behalf of the appellant, Ian Mulaski. I'd like to reserve 5 minutes of my time for rebuttal. I'm hoping to focus my time this afternoon on the first claim raised in the briefs, and of course, if the court has any questions regarding the remaining claims, I'm prepared to answer those questions. The first claim concerns whether or not the trial court erred by denying my client his right to counsel of choice at trial. In the Gonzalez-Lopez case, Justice Scalia, writing for the majority, said that an element of the Sixth Amendment right to counsel is the right to, quote, choose who will represent the defendant. He also referred to it as counsel of his own choice. But I recognize that the right to counsel of choice is not absolute. The courts have clearly said that. And a request for a continuance to accommodate a request to have counsel of choice can be denied when there is a countervailing public interest in the fair and orderly administration of justice. Now, I think recently the Fourth District Court of Appeal in the Perozzo case explained what an appellate court is to consider in this regard. They said any denial of an accused request for a continuance to retain counsel of choice must be based on an adequate inquiry into the surrounding circumstances and proper findings to show that the defendant's constitutional right is not being arbitrarily denied. The court went on to say the factors to be considered by the trial court include the following three factors. One, whether the motion is being made in bad faith or as a delay tactic. Two, whether a continuance would prejudice the state. And three, whether the court schedule would not permit a continuance. If you apply those three factors to the record in this case, I submit the only conclusion is the judge in this case erred by denying Mr. Mulaski his right of counsel of choice.
Could you address the state's argument on the lack of preservation for this claim?
Sure. Well, again, as I've argued in my reply brief, magic words are not required. There's no question that the trial judge was on notice as to what the request was. The request was for Mr. Mulaski to bring in other counsel. The judge considered that request and ultimately denied it. Yes, Mr. O'Mara, when showing up, didn't say, I'm raising this claim on behalf of Mr. Mulaski pursuant to the Sixth Amendment right to counsel of choice. I don't know of any of the cases where this has ultimately been granted.
Right. Well, we recognize that, there's no magic words, but here, wasn't it really, what I thought was profound as well is Mr. O'Mara said, I've been talking to, I guess, the client for months about this. Which it really struck my attention that this was not all of a sudden I want new counsel. He said to the trial judge in testimony, I've been talking to him about it for months, and I told him about my calendar. And really, wasn't it if there's a continuance that can be granted, great, maybe my calendar are open, but if it's not, I understand and I'm out. It wasn't really, I want this attorney definitively, and it wasn't raised in that context to the trial judge.
All right, a couple things. I disagree that it wasn't clear to the judge that Mr. Mulaski wanted Mr. O'Mara to take over the case. The judge considered that request and denied it. I agree Mr. O'Mara was very respectful in the way that he made this request, but he did say, look, I'm going to be retained if you grant a continuance. I simply can't do it on the October 23rd date that it's currently set. So the other context that I think you need to look at as far as the family saying they talked to Mr. O'Mara for months, and I think that goes into the greater issue as to clearly this record shows that my client wasn't making this request for purposes of delay or in bad faith. We have to understand what was going on at this time. What was going on was obviously COVID. The state cites three motions to continue in its answer brief. But if you look at those motions, all of those motions were to continue this case from one case management to the next, not to continue a trial date that had been set. The first time a trial date was set in this case was in September of 2021. Now, just before that, the previous motion to continue the case management had cited to the fact that the parties were still trying to get the depositions. And in fact, at that September 2021 case management, the last deposition was still scheduled to take place a couple days later. So it's only at that September date, when we've now gone a year and a half since COVID began in March of 2020, where no trials are occurring. And you can imagine that the Mulaski family is thinking to themselves, this case isn't ready to go to trial. It's been dragging on for months and months and months. We didn't even have vaccinations until April of 2021. So jurors were not coming back into the courtroom until after that date. In fact, if you look at the Florida Supreme Court's administrative order, speedy trial was still suspended until October 4th of 2021. That's the date of this status conference or pretrial case management conference when Mr. O'Mara showed up. So you can imagine that when Mr. Mulaski shows up at a very brief Zoom case management conference in September of 2021, the judge says, okay, what's the status? Where are we? And both parties say, we've now completing discovery. I think we can put this on a trial docket. And the judge says, okay, we'll put it on a pretrial for October 4th, and we'll go to trial on October 23rd. That's the first time Mr. Mulaski would have been on notice, hey, if I'm going to make a switch, we've been talking to Mr. O'Mara, now's the time to do it. And the very next court appearance is when Mr. O'Mara shows up and makes this request.
Well, why not speak up at that time and say, yeah, I'm looking at this other counsel that I've been talking to for a while, and I don't think he can make it in October of 21 for that trial.
Why did Mr. Mulaski speak up at that Zoom
Sure.
conference?
Yeah.
Mr. Mulaski wasn't even addressed at that Zoom conference. They don't even say, hello, Mr.
Well,
Mulaski.
no, I mean, the counsel. I mean, why didn't counsel at that point mention something?
I think the cases somewhat recognize this. There's a tension in these cases because the current counsel wants to stay on the case, usually, and so the current counsel doesn't have a great incentive to say, and in fact, I don't know if current counsel in September even knew that they were talking to Mr. O'Mara. He was clearly aware of that by October 4th. So again, the first time that Mr. Mulaski would have been told this case is now being set on a trial docket, the very next court appearance, which is still 3 weeks prior to the trial, Mr. O'Mara shows up and says, the family has made arrangements to bring me in. I will accept this case, but I haven't filed the notice of appearance unless you can continue it to another trial docket. Let me focus on two other points real quick also. Well, actually, let me focus on what the trial court's two reasons were in this case. Only two that were given. The first one is this, and this is on page 224 of the record. Mr. O'Mara, I'm usually very lenient when it comes to picking counsel, but I have full confidence in Mr. Hudson's ability to try this case competently. As you know, he's my former law partner. First reason the judge gives is, I'm normally really lenient for requests for counsel, but this one happens to involve my former law partner, so I'm not going to grant it. I submit, again, the standard of review is mixed. In Madison, this court said it's a bifurcated. You give deference to factual findings, but you still have to look more closely at the legal conclusion that affects my client's constitutional right. But even if this was under the arbitrary and capricious abuse of discretion standard, it is completely arbitrary to say, I would normally grant this, except for you're asking for my former law partner to be kicked off, and therefore I'm not going to grant it.
And your position is that this would be structural error, so that's as far as we would go, is this is an abuse or something like that, and we don't have to look in how well his existing counsel did.
I guess, I think you're
Or
saying
the flip side of that question is how do we determine what prejudice is in a situation like that?
So it's interesting, right? So the first question that must be answered by the court is there error? If you reach the conclusion that there's error in denying the right to counsel of choice, then yes, the U.S. Supreme Court has clearly said it's structural error. You cannot go back and look to see if harmless error would apply because, in Justice Scalia's words, how can you judge what a different attorney would have done and compare it to what this attorney did do? Now, there is still a prejudice component to whether or not the trial court was correct in denying the request for the continuance and the right of counsel of choice. So prejudice still comes into play to determine whether or not the trial court made an error. But if determination is made that the trial court made an error, harmless error cannot apply at that point. The U.S. Supreme Court has said that it is structural error.
Mr. Efferman, I'm going to try to keep up with you, but I'd like to go to issue 2 a little bit and talk about the JOA motion and the phase-on test in particular. Judge Artal in the 4th District recently called into question the application of the phase-on test and whether statutory changes that have occurred since that case was decided call it into question, and the 4th District has certified a question to the Supreme Court to that effect. Could you address the reasoning in that opinion and why phase-on is not still good law?
Obviously, that whether phase-on is still good law is going to be decided by the Florida Supreme Court, hopefully, in the certified question. I think it's
But you're asking us to apply it here, so I want to make sure.
Sure. Well, it still is the law of the state, understanding what's recently been certified. I think it's a close case. I think, on the one hand, the state's argument is that his actions the second time around in preventing her from being able to open the door allowed him more so than what would be expected in a normal attempted sexual battery to attempt to continue to try to carry that out. I understand that. The best case I would have to refute that argument would be the Walker case from the Florida Supreme Court. In Walker, the people were initially at the front of the convenience store and they were ordered to the back. I would submit that being ordered to the back would demonstrate that you were clearly doing that to avoid detection. And yet the Florida Supreme Court in Walker did apply phase-on and said that that was not, the movement in that case was incidental to the ultimate underlying crime in that case.
Would you concede that the cases are all over the board when it comes to the degree of movement required in these
Yes.
cases?
That you can't look at a particular distance or length or even time. Again, you have a convenience store in Walker that's back of the convenience store, and they said phase-on applies. It's not kidnapping. You have other situations where courts have said that perhaps with even less movement that phase-on still, it meets the phase-on standard for establishing a separate kidnapping. So as a close case.
But as a matter of, as a JOA analysis, though, I mean, she testified in detail as to what actually happened and described getting to the door, opening the door, and being dragged back in, picked up by her torso, and then thrown back on the bed, none of which has anything to do with an attempted sexual battery at that point. The attempted sexual battery happens when he then starts groping her again. So there seems to be a separation enough that, looking at it as a matter of law, whether there's enough to get to a jury, that sounds like enough. How do you make that? How do you make the argument that it's one continuous event and not two separate crimes?
I concede that that's clearly, in my mind at least, the more difficult argument of the three substantive
Which is
claims
why you
that I've
opened with
raised.
issue one.
I have,
I get that.
and then even issue 3, I think,
Sure.
changing a jury instruction in the middle of a closing argument, I can stand up here and argue if I had another 20 minutes on that, but in this, it's not maybe the best practice, but I quoted word for word defense counsel's argument below. The judge acknowledges the close issue, and I've presented it to this court, but if I could, and I realize that I'm in my rebuttal time, I do want to go back.
And I am going to extend your time by 4 minutes, and I'll do the same for the appellee, given the complexity of these issues.
Thank you, Your Honor. The other reason that the judge gave to deny the request for the continuance was this. This is on page 225. We could accommodate it in November or December, but I think it's unlikely, so I'm going to deny the motion to continue. I'm not even sure what that necessarily means. The judge initially, in the first part of that first sentence, says we could accommodate it the following month. It's only going to be a one-day trial. That was just said, but then I think it's unlikely. If the record would demonstrate that the judge then reached out to the clerk or the judicial assistant and said, do we have any openings in November, December? And if the answer was nope, the only way we can do this is now come January or February, maybe that would be a stronger argument for the state. But for the judge to acknowledge we could accommodate it, but I think it's unlikely, I'm denying it. The judge didn't, under the third factor that's considered, could it fit into the court's calendar? Based on what the judge initially said, it could have fit into the court's calendar. So again, when you apply these three factors, was this done in bad faith? The state hasn't alleged, and there's nothing in this record that would demonstrate that my client raised this claim in bad faith, or for purposes of delay for that matter. Again, after COVID, everything had been delayed. And the only other point I make about that is, if you look at the Supreme Court's order suspending speedy trial up until October of 2021, there's only roughly 5 months of delay in this case, 5 months of non-COVID delay. That's not a very old case by other standards. Madison, I think, was almost 1.5 years old. And in applying the second factor, was there prejudice to the state? And there is no prejudice to the state, very little at the very least. The thing that they pointed to was both the time, again, explained by COVID, and the fact that subpoenas had been issued to witnesses. I've reviewed hundreds of records where there's 3, 4, 5 rounds of subpoenas being issued by the state because trial times change. So again, ultimately, when you look at this case, when you apply the three factors, certainly when you do the the type of review that's required under Madison, the factual findings are not supported by the record, to the extent that the judge made factual findings. The two reasons that the judge gave, it's my former law partner, that's arbitrary, and I think we could actually accommodate you, but it's unlikely, but then never even checked to see if it could be accommodated. Those are the only two reasons in the record. That would be...
Is it relevant that it looks like your client had a couple different lawyers before the one that went to trial? Am I reading that correctly, or
My understanding is Mr. Hudson filed shortly after the information. Mr. Hudson had co-counsel,
Right.
Ms. O'Connor, that ultimately joined for the trial, but the only indication in the record of the lawyer that my client wanted was Mr. O'Mara pursuant to the October 4th transcript. So, but of course Madison talked about that the request for the lawyer in that case was the fourth request for a lawyer, and nevertheless this court in Madison reversed and found that the judge erroneously denied the right to counsel of choice.
Can I ask one question? I want to make sure you do have some rebuttal time. But on the jury instruction issue, I'm having a hard time understanding what the prejudice was. So his lawyer, the trial lawyer, claimed like, oh, well, my presentation would have been different. I had this PowerPoint already, and now like this jury instruction in the middle of my closing argument messes me up. It would have been different. But there was a 20-minute gap between the charge conference and closing argument. And so I'm having a hard time understanding what the difference would have been in all that. And is the obligation on the defense lawyer to go into more detail other than just saying, oh, it would have been different had I known?
So just to put it in perspective, it wasn't brought up by the state at the charge conference. It was brought up by the state in the middle of my client's defense counsel's closing argument. And even then, the judge didn't say, I'm going to give it. The judge says, we'll address it when closing arguments are over. So the assertion would be this. Regarding the time frame that you referenced, Your Honor, conceivably, if defense counsel had prepared not expecting that, and therefore, and then the state would have brought this up, defense counsel could have said, Judge, I need more time other than that 20 minutes because now I need to rearrange my PowerPoint presentation. And I think the concern would be this. He's not arguing that it's a defense to this, but now the jury's being told that it's not a defense, and potentially he would have presented his argument different to the jury and said, we're not saying it's a defense. You're going to get this instruction that tells you it's not a defense. Nevertheless, these are all the reasons why you should find my client not guilty. He was deprived the opportunity to do that because, again, in the middle of his closing argument, the state first brought this up when they easily could have brought it up during the charge conference, and he didn't get an opportunity because, again, the judge didn't even rule on the request until after the closing argument was over. I'll reserve the rest of my time for rebuttal. Thank you.
Counsel.
May it please the court. My name is Charlie Lee. I represent the state of Florida, the appellee in this case. There are two common factors in most of the cases that resulted in reversal because a defendant was denied his choice of counsel. The first is that the defendant voiced his dissatisfaction with his current attorney, and that didn't happen in this case. That is the harm at the heart of Gonzalez-Lopez and many of the other cases. And Madison, which I think is...
At what point during the hearing would Mr. Mulaski have had an opportunity to say that?
Your Honor, that's unclear because he didn't speak during the hearing that they had when Mr. O'Mara came in.
Wasn't he, was he on Zoom for this one?
That's what I took from the transcript,
Right.
that he was on Zoom.
Which is not typical either. I mean, you know, pre-COVID, there was a greater chance that defense would actually be in the courtroom so the judge maybe could interact with the defendant and ask those kinds of questions.
I agree, Your Honor. But it's clear from the record that Mr. Hudson and Mr. O'Mara, they were questioning whether they were going to work together or not. So it appeared that Mr. Mulaski, what I get from the record is that he wanted either both of them as his attorneys or perhaps just Mr. O'Mara. It wasn't clear. They even said that they might be
I thought the
co-counsel.
judge proposed that as a possibility, and I thought they rejected that as an idea. but
Not from
maybe-
my reading of
okay.
the record. It says whether Mr. Hudson stays, Mr. O'Mara, this is Mr. O'Mara in the record, it's 223. Whether Mr. Hudson stays involved, as he very well may, or if he doesn't, there's just going to be that period of ramp up when he's talking about he doesn't need this continuance for preparation time. He needs this because he just can't do the trial in October. What I take from that is that Mr. Mulaski was not dissatisfied with Mr. Hudson. He never said so during trial, and that he just wanted Mr. O'Mara on the case as well.
And doesn't O'Mara say, Judge, I know this has been on the docket for 750 days, and so I understand if you don't want to continue it, and that's fine. I just won't be able to do it. I mean, wasn't that the tone? That's the tone I gleaned from the transcript.
Yes, Your Honor, and that's why I argue it's not preserved. This isn't a case where Mr. Mulaski said, I have a right, a choice to counsel, or any of his lawyers brought up that he has a choice to counsel. and that they really wanted Mr. O'Mara to be on the case. It was more presented to the court that if the court could accommodate it in its schedule, then Mr. O'Mara would come on, and if he couldn't, he wouldn't, which puts the court in an awkward position. It really invites the error because the court's being given almost a choice of whether to let Mr. O'Mara on. They're inviting the court to make that choice without applying the McKay factors.
What would the proper objection have been? Like, what should Mr. O'Mara have said in that circumstance, recognizing he hasn't appeared in the case yet?
Well-
And he's there basically by grace of the judge being allowed to speak. Should Mr. O'Mara at that point said, Your Honor, I object, and you're depriving my client of his right to his choice of counsel? I mean, what are the special words that should have been said that weren't uttered here?
There's no magic words, Your Honor, as the appellant has stated. However, he could have done what Mr. Madison did in that case and sent a letter to the judge saying he was dissatisfied. He could have brought it up during trial. It just never was mentioned. His dissatisfaction with Mr. Hudson is not anywhere in the record.
What if he just thought that Mr. O'Mara would do a better job at trial?
And he may
I mean, he
have.
may not have been dissatisfied with Hudson, just thought that O'Mara was his better shot.
That's a possibility, Your Honor.
And what would that letter have looked like? Your Honor, Hudson's all right, but, O'Mara, I mean, he's my ticket. I mean, I don't understand.
None of the cases speak to a situation like that, where a client wants two counsels at once. It kind of gets into the dissent by Justice Alito and Gonzalez-Lopez, where the focus of the Sixth Amendment, Alito argues, that it's the assistance the counsel provides, and that's something Mr. Mulaski got, that this choice of counsel, it really plays more into, my argument is that it plays more into where the defendant can't get along with his counsel or doesn't believe or have faith in the counsel he has. That's where the Sixth Amendment gets violated. I think when you have a person that's perfectly satisfied, I know this is different than Your Honor's hypothetical.
No, but that's okay.
But if you have a person that's perfectly satisfied with the attorney he has, just wants another set of eyes and ears on the case, I don't think that violates the defendant's Sixth Amendment right. He has that effective, I know that the standard's not effective assistance of counsel. That's clear from Gonzalez-Lopez. It's a higher standard than that.
Well, the defendant had not one but two lawyers who could have said, we don't want to go forward without both of us on the case, or in the least, Mr. O'Mara on the case, judge.
That's correct,
No
Your Honor.
definitive statements whatsoever in that context, but correct me if I'm wrong.
No, Your Honor, that's my argument, that there's no, he never expresses that there's any, one of the McKay factors, the six McKay factors, is adequacy of counsel that's provided. He never said, no one at any time said that Mr. Mulaski's two attorneys, Ms. O'Connor and Mr. Hudson, were inadequate, that they needed more counsel. That was never brought to the court.
Is it a different query, though? Let's just say we're looking at it as an abuse of discretion question, and we have a judge that really doesn't have a reason why he wouldn't continue it other than, I guess he's under pressure because there's such a backlog in these trials, and he's not going to continue this one, even though he knows the implication is, it's been made clear to him that if he doesn't grant the continuance, then this other lawyer is not going to be able to come in, the one that Mr. Mulaski has chosen. Does there have to be more of a consideration of the impact of the denial of that motion to continue, other than, I think you have a fine lawyer, standing there right now, and we're going to move forward just because I got a lot of other cases behind yours, thanks to the administrative order from the Chief Justice?
Yes, Your Honor. That's the second element that's common throughout the cases until possibly Madison. I'll address that after I answer Your Honor's question. In all the other cases, you'll see an arbitrary or legally erroneous reason. So it's a policy, Perozzo, I don't let defendants run the show. In Gonzalez-Lopez, it was basically, it seemed like the judge was looking for ways to find violations of the attorney's ethics code to keep the pro hoc vice attorney off the case. In all these cases, there's a mechanistic policy or just an absolute refusal, an arbitrary decision. The judge doesn't say, unlike the judge in Mr. Mulaski's case, the trial judge won't say, well, I don't have many dates, and we're running out of dates for the year. It's just, I'm not going to do it unless you can give me a better reason than you want a new attorney. That's just an arbitrary policy. And that didn't happen in this case. So those are the two things: that dissatisfaction with counsel and an arbitrary or legally erroneous. One of the cases that the appellant mentions in his briefing is Inri Doe, which is a case out of this district where the trial court erroneously believed that a public defender couldn't defend in a family matter, which was, the court found was wrong. So that's a legally erroneous reason. So I think in those cases, that's where you would have a structural error. But in a case like this, it's hard to apply that. And a couple of things I misquoted in my brief. One was regarding the preservation issue and the jury instruction issue. And another thing is, in Madison, I wrote that there's not a discussion of the structural error in Gonzalez-Lopez. It is mentioned in there, and it is applied as a per se reversible error. But in Madison is different than all these cases, I think, because this court stated that because the court almost had a small Nelson hearing, which isn't the standard. That's an effectiveness of counsel. Because the court didn't apply the right process, didn't apply the McKay factors, and then the record didn't satisfy the McKay factors, and I'd argue in this case the record does, that was a per se reversal. So there wasn't necessarily, construing Madison in the light most favorable to the appellant, would be a case where maybe there wasn't an arbitrary or legally erroneous denial of the defendant's motion to continue the case to get the new attorney on. That's where I'd agree with the dissent in Madison. The trial court has to have that ability to keep the docket moving. And in an era with COVID, and that's brought up a lot, it's all the more important because now there are months and months where no cases are happening, and a massive backlog will ensue from that. And cases they're going to keep coming in. Crime rates and arrests are not going down. So it's even more important in COVID to get these cases resolved, tried, and on time. And that's why the trial court in this case did not abuse its discretion. It wasn't an arbitrary policy. These were very real and extreme time constraints that the trial court would have had.
If we could move to the second issue and talk about the motion for judgment of acquittal. This court must apply Faison, is that correct?
Until the Supreme Court overrules Faison, if it does.
Right. Are you familiar with Judge Artau's opinion in Parrish v. State, where he calls into question whether that's still good law in light of the amendments to Chapter 775.021 and subsequent amendments in the kidnapping statute as well?
I'm not terribly familiar with it. I think I've read about the question whether Faison is still valid. Until it's not, I'll argue that it just doesn't apply to this case because there's an entire second incident. Just factually, this case would meet the Faison test.
Right. So applying it, this case satisfies it, but we would certainly need to apply that test here.
Yes,
Right.
Your Honor. And as Your Honor pointed out, these cases are all over the place. I mean, one set of facts can be very similar to another. The McDonald's case, Nino, that I cited, where the employee goes into the bathroom, sees a male, and he brings her back in to assault her. That met the Faison test, but in some other cases where something very similar happens, other districts have found it doesn't. That should be resolved at the Supreme Court level because I think there will be a conflict.
Well, what is it? What principle is at issue and at the heart of the Faison inquiry? It's not a double jeopardy inquiry, right?
No, well, to an extent. I mean, The heart of it is that not every forcible felony would be a kidnapping, that they couldn't be double charged for, doubly punished for one act, whether that's double jeopardy or not. But that's the heart of it. Whether this was one act, it's not, because he's already committed a sexual assault on this woman on the, of some nature on the bed. Now he is furthering that crime by confining her, preventing her. And one thing that I think really goes in the state's favor is that he let her go, or she got away, and she was almost, he somewhat consensually let her go to get her keys. That was her ruse to get out of there.
Right,
And
and so
then-
I want to pause there, that you've argued that if we were to reverse, then there should be judgment for false imprisonment, and the appellant has conceded that. Isn't there some tension in the idea that the defendant could be convicted for both sexual battery and false imprisonment, but could not be convicted for kidnapping and sexual battery? Let me just complete that, particularly in light of the legislature's clear pronouncement that there can be multiple punishments for crimes committed in the same episode.
Oh, I think so, Your Honor. I mean, I'd argue here that, as I recall, the elements for kidnapping required that it would be in order to facilitate a felony, where false imprisonment isn't to do that. So that, I think that language is what courts find, that it can wrap up the actual felony with the crime itself. I see Your Honor's point, that so would a false imprisonment if it's part of what, what they're doing, that then every case involving a forcible felony would have a false imprisonment element as well. I can see that. But I'm glad the appellant conceded at least that it's not an all or nothing in this case, just based on the elements.
But the only way that a JOA, and considering this on a JOA, makes sense is by considering the commission with the intent to commit or facilitate a commission of a felony as an element that needs to be proven separately. There needs to be separate evidence. It can't be the same. There has to be some sort of separate intent and not just minor as part of the other crime. It has to be a separate element that we're talking about, not double jeopardy. And so I guess I'm a little bit confused by your answer in that respect.
Your Honor, I think in this case, in these cases, it's always going to be a close case. And at some point, whether this case gets to the jury or not, the judge, that's going to depend on the facts, and they're going to be very close facts in cases where a kidnapping is charged with a forcible felony. In this case, I think it meets where she gets off the bed and gets away from him and is going out and getting her keys, and then all of a sudden he decides to grab her, put his arm over her mouth, as I recall, silence her, things like that. It's almost as to commit a separate felony, but he's already completed one. There's a consensual break between the two, and whether the state could charge him for another attempted sexual assault on the victim, I don't know.
I mean, you could have attempted to grope her like right there at the door or in the hallway or something like that. But that's not, from a criminal's perspective, probably not a good idea. And so isn't it fair just to characterize what he did, pulling her back and getting her in the bed before the next crime starts, as that's what kidnapping is intended to criminalize?
Yes, Your Honor.
Yeah.
And
false imprisonment, it could be coexistent. I mean, it could be false imprisonment could be involve the same criminal conduct as the sexual battery, the attempted sexual battery. It's just that the way the elements are worded, you have to prove different elements, or at least one different fact from each of those two crimes, get you out from the double jeopardy component, and otherwise the legislature said it's fine to criminalize the same criminal conduct two different ways.
Well, I think, Your Honor, if I understand your question right, the state has an interest in preventing defendants from furthering their crime, concealing their crime. Right. And I think in this case, he's furthering his crime. He's also further concealing his crime and trying to commit another crime. I think those facts, that's where the jury would decide whether that movement was to do those things. But the state has an interest in preventing defendants from doing that, even if they're committing the same crime before they detain the person. That's where I think that the court made the right decision in letting the jury decide whether that detention met the elements of kidnapping.
Can you address the jury instruction?
Yes, Your Honor, and I wanted to
Argument.
clarify something about, I made a preservation argument in that I should not have had. The defendant did bring up the timeliness, that it was sprung on him the last minute. I apologize. But in that case, the defendant brought it on himself. I mean, it was discussed before, it was obvious that this would come up, and I don't think the defendant.
I mean, was there a motion in limine filed by the state, like saying, make sure you don't mention intoxication in your closing argument or anything like that?
No, and I don't know that any prosecutor would do that. It's known that it's not a defense to any crime. And the defendant mentioned over and over again, in fact, in the record, he mentioned, I'll try to do this quickly, I see my times. The defense attorney, Mr. Hudson, or the defense attorney making the closing says, yeah, you hold people accountable, but when you are considering what they would have done or what they intended to do, you should think about the entire context. Ian Malowski was intoxicated. He was inebriated. He was puking, stinking drunk that night. That's on page 333 of the trial transcript. He made that his defense there, and that's something that he shouldn't have done. And he invited the state to ask for this jury instruction that had already been discussed. In that case, I don't think that any prejudice ensued. It simply told the jurors what the law is. And I don't think that there's any harm from telling the jurors that when a defendant makes a defense like that, that's not a valid defense, that he can claim prejudice because the jurors were instructed in accordance with the law. Thank you, Your Honors.
Thank you, counsel, and I will ask the clerk to add a minute for the appellant, please.
Thank you. May it please the court. Judge Thomas, let me attempt to do a better job of answering your question. I believe that the trial court had the same concern that you do. How serious is Mr. O'Mara about coming into this case? And this is, I think, 223, 224. The court, at this point, do you know if you're going to be retained, Mr. O'Mara? That was the judge's way of kind of getting through some of this, him tippy-toeing around this, you know, if you can let me in, great, but we need to move it. If not, okay, we'll proceed. So in response to that question, do you know if you're going to be retained, Mr. O'Mara? I am, Your Honor. You're confident that would happen as long as, Mr. O'Mara, yes. So I think the judge also concerned, how serious is Mr. O'Mara really wanting to come into this case? But Mr. O'Mara put to rest any concern at that point. He answered yes, if this can be moved off that October trial date, even to next month, because they were discussing November. Mr. O'Mara didn't jump up and say, oh, I'm not available in November either. So November was on the table. I'm going to be retained. I just can't do it on this particular date. The judge was aware of that, and the judge said no. So then, again, I come back to this reason. I disagree with my distinguished colleague on the other side. When you talk about judges and the reasons they've given across the state, when courts have reversed, I would think this reason's at the top of the list of arbitrary reasons. The two reasons he gave is, number one, I think we could actually do it, but it may be unlikely, but he never checks. But more importantly, I'm normally lenient on these. I would normally grant this, but this involves my former law partner. That can't be the reason to deny Mr. Malowski. So every other defendant in the world, represented by anyone other than Mr. Hudson, this judge would be lenient and would grant the continuance and allow him to have his constitutional right of counsel of choice. But because it happens to be his former law partner, he's not going to allow it. That's erroneous. It's erroneous under a de novo legal review. It's erroneous under an abuse of discretion standard.
What about the point that the constitutional right doesn't go so far as to give a defendant a right to two lawyers? I mean, it's unclear. I acknowledge, having read the transcript again, that it sounds like, hey, O'Mara wants to come in and we're going to work together.
He's not clear about that. He's saying, yeah, I think it was
Well,
suggested.
but isn't the onus on O'Mara? I mean, so O'Mara doesn't even, I mean, why didn't O'Mara just file a notice of appearance and then deal with it from the other end?
I think that's true in every one of these cases. You see that being explained by the attorneys that want to come in. If they file the notice of appearance, they're on the hook for the date that they're unavailable. So the way
Sure.
they go about handling this is, let me jump in and ask the judge, look, I can come in, but I need you to move it off the current date for whatever reason that might be, whether it's because I need more time to prepare or because, as Mr. O'Mara said, he happens to be in court somewhere else on the exact date of this trial. Push it back to another date and he can handle it. I think Mr. O'Mara seems to say in response to those questions that, yeah, we may handle it together, we may not. I think that's, again, his way of being polite about this, but clearly the request is for him to be lead counsel moving forward. I don't think there's any requirement in any of the cases that Mr. Mulaski would have to express on the record why he wants a different attorney. That would go against the constitutional right of counsel of choice. Clearly, he's made the choice. He's on this call. He's not speaking up and saying, no, I don't want Mr. O'Mara. And so the fact that he wants Mr. O'Mara is all that we need to know, that that's what he wanted for counsel of choice, and the judge's ultimate ruling denying that denied my client that constitutional right, and under the structural error standard, this court should reverse.
Can it just,
So if-
go ahead.
I was going to say, so if we agree with you and you're requesting a new trial, your client understands that's resentencing, new sentencing, and
A new trial.
all that goes with it. and
Correct.
Potential resentencing.
Right, so yes, my client understands the risk that if this is granted, and this case were to proceed to a second trial, absent the same judge presiding over that trial, the protections of the current sentence would not remain in place, and he risked getting more time than what he got pursuant to this downward departure sentence, yes.
And what if instead, on the instruction argument, let's say instead the state attorney, the ASA, objected to the continued comments, including the one that was just read back by Mr. Lee, and they asked for a curative instruction instead to the jury. I want the jury to be instructed that intoxication is not a defense.
That would be no different. But objection to don't continue to do this, so maybe after, I saw it two different places, it was either 7 times or 10 times. The prosecutor initially said it was 7 times, and then it was 10 times later on when
So
they
you
argued
can't
this.
do curative instructions either during closing argument because,
Again, not in this context. An objection to stop him from doing that, by all means, stand up after he does it the first time. If you think that this is somehow misleading the jury into believing this is a defense, let's stop him from doing that. But the time to do this was the charge conference. I think this would apply in every kind of case, civil, criminal, whatever it is. If you're going to come up with a new instruction in the middle of defense counsel's closing and not even rule on it until after the closing is over, of course, again, we have to accept what he said as face value. I would have changed my presentation in this case.
sure,
So
but
the state-
counsel also knows, though, what that instruction, it's a standard instruction, knows that it's there, wasn't given, but there he is making the argument to the jury during closing. It sounds a lot like,
Invited error? I don't think so.
forgive my client, he was stinking drunk.
Again, the state could have filed a motion to prohibit that argument from being made. This could have been discussed, and again, both parties are presumed to know what the potential instructions are. Charge conference is the time to bring that up. You would imagine that a reasonable prosecutor would say, Judge, they haven't necessarily made this argument. They didn't put on a defense. In opening, they may have mentioned it once, but I want to prevent them from being able to bring this up in closing, and/or I want to give the instruction so everyone knows that this is not a defense. That's the time to have raised it so it could be addressed at the charge conference, but to bring it up for the first time in the middle of closing deprived my client's defense attorney from the opportunity to properly address the jury during closing. Thank you. I'd ask this court to reverse.
Thank you, counsel. Thank you both. This court will adjourn.
All rise.